Good evening, friends. And as they say, that the lawyers' vacation start, but their urge to learn always continues. And those who excel actually either go out or take a deeper dives into the perspectives. And today, in that endeavor, we have with us Mr. K. Vaitheeswaran, an advocate from Madras High Court, and he also has an office in Bengaluru. A topic which we have been discussing, even a common man speaking, digital personal data protection. What is the journey in this regard? He will be sharing PPT also with us. And thereafter, we will share the PPT on our website of Beyond Law CLC. And thank you, sir, for accepting our invite. Though it was long due, we had decided one session on cryptocurrency and all. But as they say that all things are destined, only on that moment it is done. Over to you, sir.
Thank you, Vikas, and good evening, friends. So without much ado, let me go straight into my presentation. And it's very interesting that the topic is structured as digital personal data protection and not an omnibus data protection. Now, why is this distinction important and relevant? Indian law has chosen to focus on personal data protection, digital personal data protection in that sense, rather than data protection as an omnibus version. So we are not talking about confidentiality. We are not talking about, corporate law data protection, but we're talking about something which is very different, which can affect everybody today. And this topic is even more hot and has become absolutely hyper hot because of all the crimes that are happening in the last 6 months, the cyber crimes that we see. We're talking about digital arrests. We're talking about blackmail. We're talking about monies being taken away. And the question that keeps coming into everybody's mind is, how does somebody get my number? How does somebody reach out to me? How do they have my data? Where is the leak happening? Where is the protection? So all this is probably some kind of a precursor in this form of this legislation. And that is why we have a new legislation called as DPDP. Now, if you look at the background, everybody uses this cliche, data is the new oil. But what people don't forget is that, just like oil, data leaves a trail. And at least in oil, there are now technologies to take out the oil from wherever it has fallen. But in data, you don't know where it has fallen and where it is stored. Why? Because collection of data happens naturally, sometimes automatically, and through AI. AI simply grabs and gobbles data and keeps it somewhere. Somebody is definitely playing, somebody is definitely using. And let me simply put it across. You find some technology which is beautiful, which is attractive, which is fantastic, and it comes with the tagline saying it's absolutely free. You can enjoy every aspect of this technology, enjoy every aspect of this app. Be 100% sure that you are the customer, you are the data provider. So your data has been consciously, unconsciously, subconsciously taken and dealt with in different form. So India did not have a specific law for data protection, though the IT Act did regulate personal data to some extent. The GDPR in UK is probably the best example for data protection, and it's one of the best laws that has seen across the world. So what have we done? We have gone ahead and enacted law, DPDP Act 2023. Parliament has cleared it. Lok Sabha, Rajya Sabha both have passed it. President has also given his assent. And as usual, we have this beautiful cutoff date. It shall come into force from a notified date. And so we'll have to wait for the notified date. And around that time also, we'll get various rules, which will also implement this law. So what are we focused on? Very simple. Any personal data that is collected in digital form. Or it may be in a physical form, but you digitize it subsequently. As simple as that. So let us say somebody gives you some information, some personal data information. They give you their Aadhaar card. You look at the Aadhaar card and then give it back. Nothing has happened. You take a Xerox copy of that and give it back, the Xerox copy and the Aadhaar card. Nothing has happened. You scan that Aadhaar card in your system. You have now digitized the data. As simple as that. So this is one form where physical could become digital, but in most cases today, everything is digital, and therefore people give the data and people scan it for the sake of avoiding physical and storage. So Act per se would apply to personal data in a physical form, in digital form. Physical can easily become digital depending on the way it is used. Something which is collected physically, when stored or processed or used digitally, can result in the act getting applied, and therefore professionals easily can get into the system. So then general focus would be, can you tell me when this act does not apply? That's the best way, because you don't want an act applying to you if you're an individual or a consumer in some cases. Therefore, they very clearly say personal data processed by an individual for personal or domestic purposes. And as usual, like in any other law, any key part of the legislation, any key word would be left undefined. So what is personal purpose? Nobody knows. What is domestic purpose? Domestic purpose, nobody knows. You just have to guess. So if any individual processes personal data for his own personal use, let us say you're hiring a driver, and this driver is for your personal use of chauffeuring of moving around from one location to another location. Now, what will you collect from the driver? You will collect his Aadhaar card, you will collect his ID card, you will collect his driver's license, you will get some sort of comfort letters from somebody from his past employment. Now you are collecting personal data pertaining to the driver, but what is it for? The purpose is personal use, domestic use. There is no other use for that. Or a servant you're hiring, you're collecting some information. It could be personal or domestic use. But just imagine a situation where a housing society collects the very same data from a watchman or a security personnel. Can the housing society then say it is personal or domestic use? Very difficult to decide. So this is what I meant, saying that there are terms which are used in the legislation which are vague, which are not defined, and therefore there can be some issue at some point of time. Personal data that is made or caused to be made publicly available by the data principal to whom such personal data relates to. That is also a situation where Act is not applicable. Now you have YouTube, you have these influencers. Now they go all around the town. They gobble up every food item in every restaurant which they can see. They make, talk about the food, boast about the content, the taste, the quality, the ambience, all those things. And they also splash a lot of personal information. They say, I'm so-and-so, I was doing engineering. When I did engineering, I didn't have this kind of food, but now I will get kind of food. And they talk about the personal data, like my wife doesn't like it. I live in this area, I live in that area. So they put tons of personal information in social media voluntarily. So somebody is a food blogger, reviews all food joints and provides all information about him. He has already put everything in the public domain. He doesn't care. The Act will not give him any protection. Act will not apply. There is a person who's an active influence in social media and maintains a public account and a private account. She writes a blog on herbal cosmetics and provides personal data about herself with reference to use and results. Everything has been shared. Act will not apply. So you have a situation where if it is personal account, private account, or a public account, if you're a public account, you can't claim any protection under this legislation. That brings to the most critical question. What is personal data? I kept giving an Aadhaar example. But is there a definition of personal data? Brilliant definition. Any data about an individual who is identifiable by or in relation to such data. Now, history would have shown that whenever a definition is simple, whenever a definition is a single line definition or does not elaborate what forms part of it or does not form part of it, litigation is assured. So personal data means any data about an individual who's identifiable by or in relation to such data. So whatever identifies somebody, numbers, identification number, KYC data, password, financial data, health data, sex orientation data, biometric data, genetic data, caste details, anything could be an identifier. UK law, on the other hand, specifies what is an identifier. India has not specified what is an identifier. UK law says a data identifier could be a name or an identification number or a location data or an online identifier linked to physical, physiological, genetic, mental, economic, cultural, social identity of a natural person. This kind of definition is not there in Indian law. Probably courts would borrow this definition when interpretation comes. So it's unfortunate that we have kept the definition very simple, and this would probably lead to some degree of interpretation, or the government, when they implement this legislation, may probably provide guidelines. They'll probably give explanation through various guidelines to say what would constitute personal data. But I can tell you, this can all be debatable areas. IP address, cookie identifier, data collected through IoT. You have all this Internet of Things. Today, you have a machine which is used in a house, but that machine also regularly monitors what you're doing and collects data and sends data somewhere. Today, when you buy a car, you operate that car and you move everywhere, but there is one chip which is also sitting in that car, which can identify the entire route of the car. So there are a lot of sensors in products. There are a lot of technology embedded into products which collects information, passes on that information somewhere else. Then you have sensors and actuators where you walk through somewhere, somebody picks up data. Let us say you're an employer and you're having a factory where people are coming in troves. So thousands of people are walking every day, and each time you cannot examine them from identification purpose and put a timestamp. Therefore, you have cameras installed across. So as they walk through, data is collected and data is passed through. Or you take your what is it called, Digiyatra, which is there in airports today. Because if you have a Digiyatra app, you're able to quickly go through all the gates and go through the security in the airport. What does it do? It scans your face, looks at your data, collects the data, and then the gate opens and you walk through. Therefore, data is collected. Data is stored somewhere. All this is personal data. Anything can attract the applicability of the act if you can be identified by the data that is being collected. So the individual whose data is collected is called data principal. These are all technical terms. There are 3 word terms that are used: data principal, data fiduciary, and data processor. So the person who owns the data, the individual, is a data principal. Data processor is the person who processes the data on behalf of the data fiduciary. Data fiduciary is the person who determines the purpose and means of processing of personal data. The fiduciary basically is the guy who collects the data. He collects the data for some reason, for some purpose, for some lawful purpose. And then he gives it to somebody to process it. That fellow who's processing it is called data processor. So typically, a data fiduciary can process personal data only for the purposes which are known as lawful purposes and only as per the act. And most important, the principal must have given her consent. Consent is a new word that creeps into this legislation for the first time. And interestingly, for the very first time, this legislation uses the word she instead of he. All the laws that you have read in all our life, the word used to be he. And then you go to General Clause Act and say he includes she. For the first time, they've said she. So it's a wonderful step forward in using her and she across this legislation. So she must have given her consent. So typically, consent drives everything. So what happens practically? You have professionals like chartered accountants, company secretaries, cost accountants, lawyers. All of them collect data. They collect personal data. So when a personal data is collected, the chartered accountant or lawyer becomes a data fiduciary. A lawyer would collect personal data even for drafting of contract. For example, if I'm executing a sale deed for my client who is a seller, I will collect his Aadhaar card, I will collect his PAN card, I will collect his address details, and if he's an NRI or something, collect his passport copies and keep them all in the document. Therefore, I've collected it, and somewhere it will be stored in my system. Now, I have to tell him why I'm collecting it. Consent. I have to get his consent saying that I'm getting your consent for using this particular data. And then the act comes to me because I'm now handling somebody's data. All businesses collect data, either for business purpose or some other purposes, statutory verification, know your vendor requirements, vendor code policies. For tax compliance, they collect PAN details, collecting passport details for identification, banks, insurance, telecom, hotels, restaurants, e-commerce, app stores, websites, retailers, associations, chambers of commerce, institutions, healthcare, and host of people collect personal data. The beauty of this is that whether they need the data or not, they collect, because that's been a practice. You collect, give me all these documents 2 times, 3 times, you collect the same data. Now, what is the effect of this legislation? Section 4 provides that a person can process personal data of a data principal only as per the act and for a lawful purpose for which she has given her consent. So I must get consent, and giving consent is an elaborate process. It must be free, it must be specific, it must be informed, it must be unconditional, it must be unambiguous, it must be clear, it must have an affirmative action. You cannot have a vague 16-page consent document. You cannot have all legal language thrown into a document and get their consent saying that I agree. No, that doesn't work. Those I agree days are gone. It has to be clear, specific, and affirmative action. Consent given for that purpose. I am hereby giving you this data for being used for this purpose. And before a person collects the data, they must give a notice to the person saying that, look, I want your consent. The notice must also specify why I'm collecting the data and what I'm going to use it for. And then the act gives a beautiful caveat saying that the person who gave the consent can anytime withdraw her consent. And if she withdraws the consent, the law says you must delete all the data that is collected. So why is this consent such an important thing? Now, most of you are, professionals or people in industry or even, retired people at home. They are the most vulnerable people who get caught in this. What happens is that today we live in an app world, and therefore every app we download, We want food, we download one app. We want edibles, we download one app. We want groceries, we download one app. Everything is an app-oriented life. We are in a complete digital world. Now look at phone and go into each of these apps and see what all permissions you have granted. You'll be amazed. Food app sometimes seeks consent for accessing photo gallery. Why do they need photo gallery of yours? Radio taxi app is seeking consent for your contact list. Music app is seeking your location data. Why does it need location data for music? I can understand Swiggy asking your location data. I can understand Uber asking your location data. Why should a music app ask your location data? Social media app asking access to calendar. Calculator app seeking access to contacts and photos. So the app world, its beauty is that if you don't give certain consents, you cannot use. And many people, because they want to use the app, they'll simply click yes, 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 get me into the app quickly. So you need to understand what permissions are required for functionality, user experience, security, privacy, and preferences. And beyond this, you cannot give consents. So going forward, because of this legislation, all these people also will change their system and stop taking consent for everything else. They'll confine to their operations. Sometimes, somebody is very smart, and they'll go to a lawyer and say, can you give me a clause in the consent document whereby the person can never file a complaint against me with reference to data which I've collected. The law has envisaged that, and you have section 6.2, which provides that consent referred to subsection 1, which constitutes an infringement of the Provisions Act, shall be invalid to the extent of such infringement. You cannot have a clause which says that I hereby forego or I give up my right to sue you in case there is a violation. You can't have such clause. This is an interesting part of the legislation. Today, we live in a world where the act is yet to come into force, yet to be notified. But everybody, everywhere is collecting personal data. Everybody is giving yes to everything. Every consent is being given. So what this act says is, look, Puttaswamy judgment is already applicable. Privacy is already important. Privacy is part of right to life. Therefore, this legislation has to protect even the past data that is collected. Therefore, even personal data that has been collected in the past, where you may have given consent or you may not have given consent, this act will apply, and therefore you have to go back to all of them and then say, look, I want your consent again to use this. And this beauty of this consent is that it should be in clear, plain language, and there must be an option to request in English or any of the languages set out in the 8th Schedule of the Constitution. You cannot give an application in consent in English saying that you fill up. That person says, I know only Punjabi. I need to fill up in Punjabi only. Then you have to give that option. So the consent format, the questions, the answers will all be in structured format. Then this concept called withdrawal of consent. She has a right to withdraw her consent at any time. You cannot make it miserable. You cannot make it complicated. If getting in is easy, getting out should be with the same ease. The law says the ease of doing must be comparable to the ease at which such consent was given. And consequence of withdrawal shall be borne by the data principal. So it is the data principal is who owns the data. If she withdraws the data, it is her call. Now, sometimes what happens, the consent has been taken. You want to protect yourself because you have taken that person's consent. And now that person says you withdraw whatever personal data pertains to me, you delete all the personal data pertains to me, but you want to keep that personal data for your own protection. Now, you can do so only if it is permitted under some other law. If some other law allows you to retain that person, for example, let us say you're in banking, you're running a bank, somebody has come to open a bank account and they give their personal data. You open the bank account. Now, then they want to close the bank account in 2 years' time. And then they say, you delete all my content. Now, your banking law might say that you must hold data about your customers for the last so many years. So if you have a law which says I must hold on to this data for some period of time, then you can hold on to that. Otherwise, if somebody says withdraw consent, you have to withdraw consent. So typically a data fiduciary, a person who collects the data, what is his requirement obligations? First of all, the consent must be an informed consent. He must comply with all the aspects of legislation. He must ensure that the collection is as per the law. The usage is as per the law. The disclosure is as per the norm specified. And if he allows the information that he is collecting to be processed by a third party, then he must ensure that it is done under a contract with similar obligations on that contractor. And most important, whatever data that he is storing and collecting, he must secure it because there are consequences. So data has to be erased if the data principal withdraws consent or as soon as it's reasonable to assume that the specified purpose is no longer being served. So this is the example I gave you. X closed their bank account. Bank is obligated under law to maintain records of the client for 10 years after closing. Therefore, retention is necessary. Therefore, bank can retain personal data. But the same argument cannot be given by a person who is not a bank. He cannot say, I want to keep it for 10 years for safety. No, you may have to delete it when the person says, yet is deleted. So this is what is new concept called as right to be forgotten. Somebody would like to be forgotten. Why should my information be available on the web? Why should there be in the social media? I want an erasure of my personal data. That is a new right that is being developed. And there are going to be some persons who will be identified as significant data fiduciaries. There will be huge, big guys who collect data. They'll be probably, mega players in the market who collect personal data. They will have more obligations than normal obligations. They'll have audit assessments, risk assessment, etc. May not be very relevant. So what is relevant now? Act would be notified and press reports indicate it can happen in the next 30 days. Act would come out in phases. Rules will be prescribed. And then time will be given for complying with the new law, because everybody has to get their systems going. They have to, first of all, go and do an analysis of what data they've collected and then find out whether the security is good. GDPR gave 2 years time. I doubt if we'll get 2 years time, but we may get at least 1 year time. So then there is a very powerful body under the law called as Data Protection Board. Now, the qualifications that are meant for the chairperson members of data protection is phenomenal. I don't know whether they'll get such kind of qualified persons. Chairperson members shall be persons of ability, integrity, standing, who possess special knowledge or practical experience in the field of data governance, administration, implementation of law related to social or consumer protection, dispute resolution, IT, communication, technology, digital economy law, regulation, techno-regulation, or any other field which may be useful. So you need a phenomenal Superman as member of this, Superwoman as member of this board to understand this. Let's see how it goes and who they actually appoint. Now, why are we talking about all this? Why we're talking about all this is that if there is a data breach, what are the consequences? Simple. What is a personal data breach? Please look at the language. Any unauthorized processing of personal data. Now, this means you're at fault. You collect personal data from that person for issuing an insurance policy, and then you sell that personal data to somebody else or share the personal data to a bank. Unauthorized processing. Or you keep it in your system where anybody can access it and somebody accesses it. Accidental disclosure. You share it with your group company. Somebody buys it out. You use it to some other purpose. You modify it. You destroy it. Or you cause some other loss to personal data which compromises confidentiality, integrity, etc. Then you have done what is called as personal data breach. Please understand, even accidental disclosure constitutes personal data breach. What does it mean? You have to spend a lot of money implementing systems to prevent accidental disclosure. You can't say, boss, I'm a victim. I'm a victim of cyber attack. I was hacked. The law does not give you any exclusion or window or exceptions. You have to protect yourself to the extent you can, and then go before the data protection board and say, look, this is all we have done. These are the industry practices. The highest level of technology protection I've taken, the highest level of cyber security protection I've taken, the highest level of audits I've done as far as the security is concerned, despite this vulnerability happened, despite that a hack happened, and therefore you should look at me differently from a penalty perspective. Those are your probably defenses at some point of time. Let me give you a simple example. Miss Prudence is an employee. She works at YMZ. YMZ is a top CA firm dealing with celebrities and HNIs. She is part of an audit team handling celebrity accounts. And suddenly she receives an email on her work desktop which says that she has won tickets to a Taylor Swift concert in Singapore. And a link is provided to guide her tickets. With super happiness, she clicks the link. System collapses, system crashes. Which means what? A hacker has come into the system and all the personal data of celebrities have been taken out. Now, who is liable? The firm is liable for breach of provisions of the Act. This is exactly what happened in many cases such as Marriott, British Airways, where GDPR flung into action and huge penalties were put on hotels, airlines, and various service providers. So this is what is the mechanism which I talked about. The adjudication process is through section 633, where the board will decide whether how much of penalty can be imposed on you, what violations you've done, what violations you've not done. They look at the nature of the offense, the gravity, the duration, what kind of personal data was affected by the breach, whether it's a repeated breach, whether somebody has gained because of the breach, what action you took to mitigate the effect, whether penalty is proportionate, effective, etc. All that they will look at and then decide. Now, why is this act so important? Just look at the numbers. Breach in observing data fiduciary obligations, reasonable failure to take reasonable safeguards to prevent personal data breach, penalty up to 250 crores. Breach in observing obligation to give the board or the affected data principal notice of personal data breach. That means you collected personal data, it is sitting in your system, somebody has hacked your system, you know that somebody has hacked your system, you don't inform the parties who's affected by this hack. Who are all your data principals who are given the data, you should give them a notice saying that, boss, something has happened to my system, there is a risk that there is a breach. You must also give a notice to the board. You don't give those notices, penalty up to 200 crores. Breach of additional obligations under section 9, 200 crores. Breach of obligations for SDP, significant data fiduciary, 250 crores. Breach and observance of duties under section 15, that is data principal has certain duties. You have certain a penalty of 10,000. Data principal means the person who owns the data. So his penalty is a minimum, most minimum. All other penalties are huge, it's applicable to persons who collect the data. So this is the reason why this legislation has attained tremendous importance, because the consequences are huge, which can simply bring your organizations to a standstill. So it's a huge impact. One more law with huge impact. It opens a Pandora's box in complaints. What is likely to follow is that somebody will simply write a complaint saying that my data has been stolen, I suddenly found some data outside, this must have been breached by this entity only. And when a complaint comes, the board has to investigate whether the complaint is genuinely true. They'll call for an inquiry. Then there is a possibility of closure at various stages. Then there's interim orders. All that is possible. And if you're still unhappy with the order of the Data Protection Board, you can always go to the appeal to the appellate tribunal under Telecom Dispute Settlement Appellate Tribunal. So what is the way forward? What message will you take after this presentation? First of all, please remember, data must be held only for the purpose for which it was collected. Which means what? Just in case can no longer be a justification for retaining data. This habit of randomly and simply collecting personal data, give me your Aadhaar card, give me your PAN card, give me your driving license, give me your voter ID, give me your passport copy. Why? Why do you want to collect? Give me 2 copies of all these things and sign true copy also. Why do you want to do all that? Just collect the data which is needed, keep it safely and securely so that you don't get into troubles. So you must be very careful going forward. That is why if you notice, a lot of people are slowly avoiding other data collection. They're trying to get other data, but even then, people are still collecting randomly and it's shared everywhere. So please understand, you are not a victim of a fraud over a phone call because it's a random phone call. Your phone number has been stored somewhere and shared somewhere or sold somewhere. Or why go to that extent? Today, everybody puts their own information somewhere in a social media. Let us say, for example, somebody lives in Bombay and then he's got a super job. He's promoted and he's become a general manager in particular organization, marketing, and he shifted to Delhi, transferred to Delhi. It's a plum job, superb job. The moment he goes and joins Delhi, he makes a Facebook post and an Instagram post and any other social media handle. He says, "I've come to Delhi. I'm now GM so-and-so, so-and-so." Or LinkedIn tells you, congratulate so-and-so for becoming GM so-and-so, so-and-so. Then everybody says, congratulations. So all that happiness is put there. Now, if let us say you're on Facebook and you post saying that I've now moved to Delhi and taken this post, you'll be surprised immediately next day or the same day, you will get advertisements for housing in Delhi, for properties in Delhi, for restaurants in Delhi, for things to buy in Delhi, all those things. Why? Because there is already a mechanism, algorithm built in, which will track your information and then based on that, provide targeted advertisements to you. That is a system which is already there and you're already voluntarily signed up for everything. So when data is put forth, it will be used, whatever you put out. That is why people keep saying, be a little careful about what you put in your handles. Try to limit the information that's not necessary for this kind of information to be available in social media. So the idea that you implement from there is build privacy into every decision-making process. Going forward, privacy notices becomes very, very important. How you draft your engagement letters becomes critical because you have to ensure that the aspects of the law is fully complied with. Every business will have to analyze and assess their operations, carry out an analysis in the context of DPDP in-house through professionals, and then do a mapping analysis of all the data. And then find out who is collecting data in the organization, what kind of data is being collected, and why is it being collected. You will find out in our studies, we have found out that most of the cases, they have found out that these data was not even required to be collected, but somebody was collecting. Some guy was collecting some data. Why? Take a classic example. You want to enter into a company to visit them for some reason. You got an appointment with their senior most person. You enter their high funda office. At the security gates, that person stops you and then collects your ID, takes a copy of your ID, takes your photograph, and then fills in this data putting the photograph and gives you a temporary ID card, which you have to swipe to go inside. Done? Your meeting is for half an hour and you come back and go out. But your data has been collected. Now, the purpose was security. Now, going forward, you can say that you should delete the data. But deletion of data would mean that entire objective was wasted. Suppose you had gone inside and stolen something. This is the best evidence I can give to the police. That so-and-so person, so-and-so time came in. You can't delete the data. So we are going to debate all these things going forward as to how to implement this legislation. Identify existing consent mechanism and change as per legal requirements. There are a lot of companies that have tools which collect data. You have to build consent formats into those tools. All communications will have to be checked from a legal advisory perspective. Website conditions, privacy policy will have to be verified. All contracts policies have to be revisited because contracts have a lot of personal data collection. So you have to build in DPDP into that contracts. Data sharing policy should be revisited. Data security has to be strengthened. The whole philosophy of this law is that strengthen your data security. Whatever you're storing, protect it, which means your existing cyber security systems will have to be revamped, enhanced, strengthened. Track further developments such as rules, formats, consents, etc. And most important, you may have to do a training of your employees, support staff, admin staff, data managers, outsource contractors, service providers, any person who collects data. You may have to train all of them saying that A, don't collect unnecessary data. B, if you collect data, ensure it is as per these norms. C, you ensure that the consent is taken from the person who collect the data. D, the consent is that particular format. Have a data protection policy for the entire group, entire organization. Have internal inspections to ensure that there's no violation. Minimize data collection wherever possible and apply what I call as the essentiality test. Is it essential? Is it absolutely essential? Then collect it. Otherwise, no. And cyber security, as I said, you have to enhance it. How do you enhance it? Apart from investing in technology, apart from investing in protection, limit access. How many people have access to this personal data? Everybody in the organization can access, then you're in trouble. Limit access to very few people who can access this personal data, then safety will automatically fall into place. Implement access only through restricted keys. Have architecture, key architecture to protect it. Develop and establish an incident response plan. See what happens if something happens, if there is a hack. Everybody joins around and completely buries the whole issue. That is what you should not do. You must have an internal response team and an external support team, mitigate the impact of that losses and report wherever required. If you don't do the reporting and take corrective action, the consequence of penalty is much more. And last but not the least, see if your insurance guys can cover this. So these are things to do, I would say, once the rules are notified, once the act comes into play in different formats. This, in a nutshell, is what we look at DPDP. If there are any questions, I'll be glad to take. And thank you for listening to this presentation.
Yeah, thank you. It was an excellent session. I thought we have approximately covered everything. And these PPT itself, they're nicely designed and it carries out the entire essence. And few of the things were, in fact, mind enriching for me also. And I'm quite sure the people would like. I've just checked out on the YouTube as well as on this. We have no other questions. So thank you. And thank you for sparing your time during the vacations. It was happy learning. Thank you.
Thank you so much. Thank you. Bye-bye.